everyone. Happy New Year. I know I said that already, but we had an influx of calls for people who made New Year's resolutions to get their legal paperwork up to date, and we love that. And we highly encourage a yearly review of your documents. With that being said, today we're going to talk about something we haven't discussed in a while. Why should you have a will? I'm Raluca. I provide estate planning, immigration, and family law legal services.
And some real estate.
And some real estate too. Yes, I did closings. And I'm here with Nina Clear, my marketing and office manager. You just heard her. So we really appreciate all your likes, shares, and comments. Your interactions help others to see our videos. So please like our videos, shares them. We enjoy helping as many people as possible with our information, and thank you for helping us to do that.
Okay, so first things first, do you think everybody should have a will?
Yes, I do.
And are you just saying that because you're an attorney who helps people by writing a will for them?
You sounds like a client. Yes and no. I can't forget that I'm an attorney, but even if I were not an attorney, I would always recommend people to have a will.
But is there people who could get away without having one?
Of course. I mean, there are many people that die every day without a will. But if there is any property and any family, whether you want them to inherit from you or not, you should have a will, because otherwise the state determines how your property and your inheritance is distributed.
So it sounds like a will can be useful not only to say what you want people to get, but also say if you don't want people to get things.
Absolutely. Let me give you an example. Say there is a person who has been married several times and has children from each marriage. They may be estranged from children from one of the marriages. Because of that, they may not want that child to inherit any of the property or money. So if they do not leave a will, children may have the right to go into court and say, I have the right to this property because I am an heir. And that could, one, tie up the other's heirs to receive the property in a timely manner, and two, lead to legal fees that the people whom you do want to inherit have to pay.
Plus the person you didn't want to get anything might get something.
Yes.
So do you recommend that people leave nothing to their estranged child?
Well, I'm not going to tell anyone what they should do with their property. That's up to each person. However, it is sometimes recommended that you leave a nominal or small amount to a child, such as $1, so that they know they were not forgotten and you deliberately didn't want them to inherit anything. Or you can say they were left out intentionally. But do keep in mind that even if you exclude your spouse or minor children, they can still apply for the courts for a year's support and may be able to get that.
That's in Georgia specifically, right?
That's a Georgia specific, yes.
Okay, so what about if you have no children? Do you think it's helpful to have a will?
Absolutely. I have had clients who had no children, but they had multiple pieces of property. If one spouse dies without a will and they don't have the property properly recorded with the county in each spouse's name with the right of survivorship, then the spouse will have to file forms with the clerk of the county where the property is and may have to pay taxes to have the property put in their name. So this could really be a problem if the spouse wants to sell the property, but it isn't in their name.
Because it can add time.
That's right.
Before they can put it on sale.
Yes.
Okay. So this may sound like self-serving, again, being an attorney, but do you recommend people use an attorney when they write a will?
I do, and there are a few reasons why. And I don't think this is self-serving at all. I understand that people can hire an attorney from a prepaid legal subscription, which my office has as well, or even download a will off of Google. The problem is when you use an attorney who isn't familiar with your circumstances, that they are what they are using is called a boilerplate will, just like you buy from a store, and it may not cover all your circumstances, your individual circumstances. So it seems like it's fine until your family finds out it isn't. And at that time, and they usually, right, they find out after you pass away. So it's in one of the most difficult times of their life. So if the will is not proper, they will have a problem to probate it. And also remember that if the will does not follow the state law, whole or part of it can be invalidated by the courts.
So what are some other things that you can say so that you can decide, like things you can decide in your will, have to say, I want this to be done this way?
Yeah, so aside from just deciding who you want to receive your property, you can also establish in a will who you want to take care of your children. If in case you pass away before they are 18, you can establish how your property is held for your children if they're minors and how it is distributed. You can also say what religion you want your child to be raised in. If you pass, like I said, before your children are grown.
And some states, they allow you to have an oral will. So you can tell people, on your deathbed, this is what I want and this is who I want to get my stuff. And if they testify to it, then that's valid. Is that true in Georgia?
It is true in the movies, but not in Georgia.
Okay.
And in Georgia, the will must be written.
And does it have to be notarized?
It doesn't have to be, but having it notarized can help to cut down on processing time.
Okay. And then is a living will the same as a will that distributes your property?
No, a living will, it's the title is a little bit misleading, but it gives advanced directives to a doctor, meaning it tells them what life savings measures you do or don't want them taken on your behalf. So it's not really a will because you're still alive
Right.
when it applies.
But you're making the decision, hopefully in your right mind, when your family's not like you're in a coma and they have to decide pull the plug or not.
Exactly.
And that kind of helps them.
Yes.
So what about if you die without a will? Does the state get your property?
It depends on your circumstances. They might, but they usually won't if you have relatives or a spouse who can be found. But this can take time.
And what about if you have a will that you don't want it to be followed anymore? So you left everything to someone and then you had a fight with them and you're like, you're getting nothing. So do you need to tell somebody about that?
You don't. You can just destroy the will or write a new one, and both of these actions will void the will.
So are there any other documents that you recommend somebody has for estate planning besides a will?
Sure, absolutely. Living will, as I mentioned, is very important. I also recommend to my clients, including immigration clients, that they have a power of attorney in place. We will talk about those in other videos, in other lives. But for now, if you have any questions, please drop them below or send a message to us. And as always, we are here to help. Thank you for watching and see you tomorrow. Bye-bye.